and thank you for joining us for today's webinar. Before we get started, we have a few housekeeping notes that we need to share. First, for the benefit of all participants, attendee lines have been muted. Should you have any questions that you would like to submit during the event, you may submit them through the question and answer space at the bottom of your screen. If we cannot address your question during today's webinar, we will follow up after the program. Second, please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the contacts listed in the email communication. Please also note that Dentons can only issue CLE credit for attendance during this live broadcast of the webinar. Participation on the live webinar must be on a computer or laptop device. So if you're on an iPhone or an iPad and want CLE credit, please move over. Credit is not available for joining via mobile devices. Third, and finally, our last important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen to the code word that will be given during this program. When prompted, you will need to enter the code word into the Q&A section of the screen. If you don't have a license in the state, you can disregard that, but for those who are here for that purpose, please keep that in mind. Those are our opening announcements. So with that, we'll begin our Cannabis Allergens in the Workplace seminar on OSHA and employment law issues. Next slide, please. I'm Amy Rubenstein. I'm a partner in the Cannabis Group located in Chicago. I've been practicing law 22 years. More recently in the cannabis space, and I'm joined today by esteemed colleagues who likewise have an area of specialty as well as providing counsel frequently in the cannabis space. Erin, can you please introduce yourself?
Yeah, thanks, Amy. Hi, everyone. I'm Erin Bass. I'm a partner in Denton's Employment Group. I'm based in our Los Angeles and Phoenix offices. My employment practice runs the gamut, a broad range of issues. I advise employers in the cannabis industry as well as other industries as well. Val, you want to take it next?
Sure. I am Valerie Faith. I practice in the firm's Pittsburgh office, and I work in the firm's labor and employment department. My practice is devoted to representing employers in all types of employment litigation, and I routinely counsel employers on termination issues and ADA and FMLA issues as well.
So I'm Julie Vanneman. I am also in the Pittsburgh office. I focus on environmental and health and safety issues. So as part of that, I counsel clients facing OSHA investigations and also provide more proactive counseling about workplace health and safety issues in the workplace. I have experience helping clients in the cannabis industry with allergen issues as well as other OSHA issues.
Thank you all. We are lucky to have these three with us today. I can tell you from experience that they are brilliant and practical practitioners in the space, and you will learn a lot today. Next slide, please. Our agenda for today is robust. We are going to cover the following topics and do so as efficiently and quickly as possible. Introduction and overview, cannabis allergens in the workplace, potential OSHA enforcement activity, proactive health and safety steps, employment issues. We have some hypotheticals and also some group participation. So you'll be able to vote and participate with us. Some topics for another day that we've heard a lot of questions about, and we're happy to answer these outside of this seminar, our summary of key takeaways, and then Q&A as well. Next slide. Next slide, please. Our context for today is to be focusing on cannabis allergens in the occupational setting. So for cannabis, that's production and cultivation facilities. And this is not about sales to consumers or product liability issues. This is an important distinction because much of the cannabis regulatory space is really focused on consumer safety. And this is a different angle because this is looking at what's going on in your production and cultivation facilities and how that impacts employees and others on the premises. This can become a very expensive issue. The potential costs include OSHA enforcement actions, which in the first instance, as Julie will describe, the first fine usually is to get compliance. It's the subsequent fines that really become super expensive. Employment-related costs, such as implementing training programs and engaging in the interactive ADA process. Lawsuits alleging discrimination, workers' comp related costs, and wrongful death lawsuits. The big money item on this list often is those wrongful death lawsuits, the personal injury cases brought by folks who were injured or claimed to be injured in a production or cultivation facility. So we try to avoid those. Obviously, the things that preceded that, but put that big one at the bottom. Next slide, please. Just a breakdown of who's going to be speaking on what issue. I will be providing the industry perspective. Julie Vanneman will be doing background on cannabis allergens in the occupational setting and the OSHA issues, and Erin and Val will be hitting on the employment issues. So a little industry perspective to start here. As many people know, the cannabis industry is growing and evolving at a rapid pace. It's really the first kind of hard product, as opposed to like an IT or software, hard product that's created an entire new industry in my lifetime. And it's fascinating to watch how this is developing. While other more hard industries have figured out their OSHA compliance issues, cannabis is still on the precipice of doing so. For me, this issue first came on my radar when working with Julie and a client asked about safety data sheets for cannabis. My background in the chemicals industry caused me to think, absolutely not. Why would you ever need a safety data sheet for cannabis or ground cannabis dust? And I learned very quickly that despite the fact that I wasn't seeing cannabis through that lens, that it does in fact fall into that category. I mean, it actually seemed crazy to me at first. And so with this team of amazing colleagues, we have figured out how to navigate these challenges, and perhaps a client who might react like me and say, an SDS sounds crazy, and how to make those things work. So we look forward to speaking more. And with that, I will turn it over to Julie. Next slide, please.
Thanks, Amy. Okay, next slide. All right, so I'm going to give a brief overview of cannabis allergens in the workplace, but 2 points before I do. First, as Amy said, we are talking about the occupational setting, not consumer or personal use. Second, just because something is an allergen doesn't mean everyone is allergic to it. So in the occupational context, we're quite used to dealing with issues with allergens like peanuts or flour, right? Which might be an issue for some people, but not for others. So for cannabis allergens in the workplace, there are a number of potential health impacts. The first category is really respiratory. Cannabis can lead to asthma and allergic rhinitis. This can mean either occupational asthma, which means new asthma, somebody who didn't have asthma before they started working in a facility, as well as work exacerbated asthma. So somebody already had asthma and it's gotten worse because of their work in a cannabis production facility. One of the important things to note is it's not necessarily an immediate effect. Somebody might start working and be fine on day 1, but not be fine in month 6. There are also impacts or potential impacts on skin and eyes because skin contact through personal handling has been associated with hives, itchy skin, and swollen or puffy eyes. Next slide. So I'm going to give a list of resources later in the presentation, so you'll be able to find these documents on your own. And I'm just listing them here to give you a sense of the kinds of materials that I'm drawing from to come to this presentation. There's an important CDC report from last year, a number of academic papers. The National Institute of Occupational Safety and Health, or NIOSH, has published a couple of health hazard evaluations from cannabis facilities. And then back in 2017, the Colorado Department of Health and Environment published a guide to worker safety and health in the industry generally. And that publication had a section on cannabis allergens. Next. Next. All right, so talking about OSHA, does federal OSHA enforce occupational safety and health rules in the cannabis industry, even though cannabis is illegal at the federal level? And the answer is, next slide, definitely yes. Very much a hard yes, so keep that in mind. Next slide. Now, when I use the word OSHA in this presentation, what I really mean is either federal OSHA or one of the state agencies that is managing a state OSHA plan. So some of the states have state plans that have to be at least as stringent as federal OSHA, but might be more stringent than federal OSHA. So it's important to be aware of the differences in the jurisdictions in which you might operate. There are some states, such as California, which are known for having workplace rules which are more stringent than federal OSHA would require. Next. All right, so if OSHA inspects your facility and you are concerned about the potential for a citation, there are two avenues that OSHA can follow in terms of issuing a citation. One is called the general duty clause, and the other is a citation under a specific standard. Next. So going to specific standards first, there are a number of standards that might be applicable in a cannabis cultivation and production facility. Two that might be especially important to this conversation are the Hazard Communication Standard and the Personal Protective Equipment, or PPE standard. And we'll talk a little more about those later. Next. So if there's a citation under a specific standard, what are the elements that OSHA has to establish to prove a violation? Next. Number one, does a standard even apply? And this is actually really important because sometimes a citation can be defended on the basis that standard is not applicable to your activities. Next. Did conditions meet the requirements of that standard? Next. Were employees exposed to the conditions? Now, in terms of allergens, really not much of a question, because if you are dealing with cannabis in a facility, you are dealing with the potential for cannabis allergens. It's more of an issue in some contexts where, for example, there's a piece of equipment and somebody wasn't actually using it, but maybe could have been using it. Next. And then was there knowledge? And by knowledge, I mean actual or constructive knowledge. So you don't actually have to have known something, because there are ways that the knowledge can be imputed to you. So if the supervisor on the floor knew about something, that can be imputed to the company. And then OSHA is also going to ask whether the employer should have known if it was using reasonable diligence of the condition. Next. So in some circumstances, there is not a specific standard that applies to something that OSHA considers to be a hazard. So what does OSHA do in that context? It relies on what is called the general duty clause. Under that clause, employers have to provide each employee a place of employment that is free from recognized hazards that are causing or are likely to cause death or serious physical harm. Next. Okay, again, going through those elements. Next. Number one, something in the workplace has to actually present a hazard. Next. Recognition is important and can be a little challenging, because recognition can be assessed based on what others knew, not necessarily what you knew. So if you didn't actually recognize a hazard at your workplace, but it's something that everybody else in the industry would have known about, then OSHA can say it's the recognition element applies to you. Next. The hazard was causing or likely to cause death or serious physical harm. I am emphasizing likely because it's very important to remember that OSHA can cite you under the general duty clause, even if there was no adverse outcome. Nobody got sick, nobody got hurt, but there was something that was likely to cause a serious injury. Next. There have to be feasible means to eliminate or materially reduce the hazard. And this is where we get into a conversation of whether the proposed abatement is economically and technologically capable of being done. I'll just add a note here that the feasibility analysis is baked in to specific standards. So if there is already a standard on something, it is understood that it's feasible to implement that standard. Whereas in the general duty clause, you can actually have discussion about whether what OSHA wants is actually feasible. Next. So penalties. So when I get OSHA issues in my practice, people often want to know what the penalty might be, or they come to me with a penalty that's already been imposed or been proposed. It's about $16,000 for a serious violation and 10 times that much for a willful or repeated violation. Those numbers go up in January of every year, so that's what they are for now. Next. But it's very important to remember that penalties might be a very small part of your overall cost of compliance. And this is because OSHA often focuses on what you were going to do for abatement. That is how you're going to fix the problem. And this is where it can get very expensive, and you might need to do some serious negotiating with OSHA about what to do. It can get expensive because it might be necessary to purchase new equipment. For example, improve ventilation so that you can decrease the amount of cannabis dust in the workplace. There could be enhanced training requirements, potential medical screening and surveillance requirements, and the development of safety data sheets, as Amy said, in terms of the hazard communication standard. Next. All right, so now that we've talked about what the issue is and how OSHA might initiate enforcement activity against you, we get to the important thing, was how can you avoid all of this? So let's talk about proactive health and safety steps. Next. So as background, I'm going to give a little brief OSHA lecture on how OSHA is going to look at this. And I say this to you because when people think about proactive steps, they often jump to measures like wearing a mask. And if you do that with OSHA, they're going to look askance at you. That's not where you're supposed to start. You're supposed to start at the top of this inverted pyramid because those measures are actually more effective at improving workplace health and safety. In the cannabis context, you cannot eliminate the hazard, right? Cannabis is your product. You're not going to eliminate the use of cannabis. Substitution is also likely not an option in terms of cannabis allergens because it is what it is. Maybe there are some strains that are more allergenic than others. I don't know, but we're going to ignore that for now. That leaves 3 other types of measures that you can take. Engineering controls are things that isolate people from the hazard. So maybe there's a grinding room where you can shut the door when certain grinding activities are going on so the dust doesn't get into other parts of the facility. Administrative controls change the way people work. Think policies and procedures. Think training requirements to get people to change how they do their day-to-day jobs. And finally, there's PPE, gloves, masks, whatever it is that can help separate the person from the hazard that you can't otherwise control. Next. So I know this is a lot of words. You don't need to read all these words. You can find this easily in your materials when you link to the CDC report. But I wanted to put it up here to emphasize that the CDC has already looked at this issue, and they have come out with a number of measures that they think cannabis facilities should be considering and likely taking. So it's important to recognize what's already been published. Under my note, could be expensive. I see the bullet point about equipment controls. So this is mitigating risk from dust producing processes. There are 2 bullet points that I marked as important, and that's because they're going to be a segue into what Val and Aaron are going to talk about in the employment context. And that is, there are going to be some people where you cannot take any measures that are going to solve the problem, right? So if somebody has a skin issue with cannabis, maybe wearing gloves alone will help and that will solve the problem, but maybe it won't. And what the CDC is saying is that PPE might not be effective for people with signs and symptoms of work-related allergies. The CDC also says that it might not be enough to reduce exposure to cannabis. You might have to have complete cessation of exposure, which essentially means that person can't work there. And so this is very important when it comes to the employment context about how you handle issues where somebody is exhibiting signs of a cannabis allergy. And I point this out because for some people, the symptoms might be irritating, like a rash in your skin. But for some people, they could be incredibly serious, leading to a trip in the ambulance to the hospital and some very serious respiratory issues. So I also know that training is critical. And that's because not everybody knows about cannabis allergens. And so they have to understand what the signs and symptoms might be and what to do about it. Because if you don't understand that, you might get somebody who says, oh, it's just my seasonal allergies, or maybe I have COVID, or whatever it is. People need to know about the issues with cannabis allergens so that they're aware of it and can do something to address the potential harms. Next. All right, so now we get to the interactive part. So if you are at a cannabis facility, what is the most important step you can take to address potential concerns about cannabis allergens? Number one, engineering controls. This would be, for example, implementing measures to reduce dust in the workplace. Number two, provide education and training so people are aware of the signs and symptoms of allergies and what to do if they occur. And number three is provide appropriate PPE to employees in your workplace. So there's a poll, if we can issue the poll and everybody click what they think is the right answer. And I'll be very curious to see what people come back with in terms of what they're thinking about what they can do in these facilities. So I'll just give a few more seconds to click your choice and finish up, and then ask my helpful administrators to put up the results of the poll. Okay, let's see the results. All right, implement engineering controls, 36%, more than half provide education and training, and 8% provide PPE. That is not surprising to me. I think that's a pretty good result. As I noted, I think education and training is a very important place to start so people understand what's going on. I'm not trying to minimize the importance of engineering controls, and certainly sometimes PPE can easily solve the problem if all you need to do is wear gloves. But that's an interesting result. So thank you for participating. Next. Next slide. There we go. So answer this question for your facility if you work for a cannabis company, or for a client if you work with a cannabis company. And the question is, does the facility have a cannabis allergen awareness program that provides education and training on the possibility of allergic reactions to cannabis in an occupational setting? Yes or no? Okay, can we put the poll up, please? Thanks. Just a quick yes or no. And I understand that if you're not in this industry, you're not going to answer. So we'll just see what we get with the results. So let's see, 3, 2, 1, results. Okay, no, 65%, yes, 35%. I think you can probably tell from what I've been saying that I think it's important to have this type of awareness program because people need to understand about cannabis allergies. A lot of people don't realize that cannabis can be an allergen. I think we all know that if we went to work at a peanut factory, that peanuts can be an allergen, but I think it's important to understand cannabis is different, not the same as peanuts, but cannabis can also be an allergen. Next. Okay, so now is where I give my spiel about the code word. As mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word cannabis into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it the first time, the code word is cannabis. Okay, moving on, next slide. And I will turn it over to Val and Aaron.
Thanks, Julie. Next slide, please. Okay. So most allergies are considered to be an ADA disability because they can significantly limit an individual's ability to work, go to school, etc. I think Julie touched on peanut allergy. You know, there are many kids that have severe peanut allergies. They can't be anywhere near a peanut. They can't go to school. They have a lot of limitations. So it's generally understood that most allergies are considered to be an ADA disability. However, it's important to keep in mind that an employee is not covered under the ADA unless he or she is a qualified individual with a disability. And this essentially means two things. First, the employee must satisfy the requirements for the job, such as the education, experience, skills. And second, the employee must be able to perform the essential duties of a job with or without accommodation. And I think this was mentioned earlier, in the case of a severe cannabis allergy, in all likelihood, a person probably could not work in an environment where cannabis was present. And for anyone that works in that industry, I understand, I've never been in a facility that manufactures it, but I know some of my colleagues have it. It appears that the cannabis dust is everywhere, and it would be pretty difficult, if not impossible, to limit someone's exposure if they had a severe cannabis allergy. But the key question in the context of this webinar is whether an allergy can be accommodated in any way. And in order to determine if an allergy can be accommodated, the employer is obligated to participate in the interactive process with the employee. And as part of that interactive process, the employer must review with the employee the essential duties, functions of the employee's job. So generally, I recommend that my clients meet with the employee, go over with them their job duties, also review their written job description to make certain that it's up to date and consistent with what the employee is reporting that he or she does. And after that, I recommend that the employer review any limitations or restrictions that the employee reports he or she has that must be accommodated. Generally, an employer is not going to take an employee's word for what their limitations are and is going to want to rely on information from a medical provider to determine what the individual's limitations are. Most work-related limitations are provided by an employee's treating provider who may or may not be an allergist, which can be problematic in and of itself. Generally, unfortunately, the limitations issued by a treating physician are too vague and cannot be used to determine what an employee can or cannot do. Further, generally, the medical providers are unaware of the essential duties of an employee's job. And for these reasons, it's generally necessary for my clients or employers to request additional information from an employee's physician. Unfortunately, you can't just call a medical provider and ask them for a note. You have to have the employee sign a HIPAA-compliant medical authorization that gives the provider permission to provide you with the information that you've requested. So let me just advance this real quick. So the normal protocol I would follow in a case like this is I would have the employee or recommend that my client have an employee sign a HIPAA compliant authorization. And I would recommend that the employer send to the treating physician a detailed list of questions along with a copy of the individual's job description so that the physician is fully aware of what the employee does or does not do at work. And I also recommend that included in the letter that there be a reference to the fact that the individual is covered under a workers' comp policy and that there is short or long-term disability benefits available to the employee. And the reason why I recommend that this be added to the letter to the physician is a physician is generally more inclined to be honest that the individual should not be returned to a work environment if they know that the employee is going to have a source of income. I would never recommend sending a generic letter to a physician, and instead would recommend that a carefully tailored letter be sent to the physician. I've seen some of my clients send kind of a form that they send to every physician that asks a lot of questions, but it doesn't really address the specific issues that the employee is reporting he or she has and doesn't really address the specific job. So at the end of the day, the entire process, the interactive process, is time consuming, but it is absolutely necessary to protect the company's interest, even if you know the likely outcome, so that you can show that you've gone through the necessary steps to try to determine whether a certain disability can be accommodated. And Erin's going to talk about more specifically about the types of accommodations that can be offered to employees. Erin?
Yeah, thanks, Val. So, as Val and both Julie have said, cannabis allergies in particular can be very difficult to accommodate. Some options are, depending on the severity of the allergy, additional PPE. I'm going to skip transfer to another position for a second and go to leave of absence. Leave of absence can be a reasonable accommodation under the ADA. You may also have obligations under other leave laws to provide employees time away from work to get treatment or to address their allergy. Brian, could you just go back forward one slide? So for instance, the FMLA or other state leave laws, paid sick leave and so forth, you may need to give the employee some time off from work. But cannabis allergies can be severe, particularly when they're have respiratory symptoms. And so you may find that, and we'll talk a little bit about this as we go in more detail, but you may find that you just cannot accommodate them in the facility where you are growing and producing and manufacturing cannabis products. In which case, really likely the only accommodation that would address their limitations is to transfer them to another position outside of a facility where cannabis is being grown or manufactured. And I've noted here that transfer to another position means, in the context of the ADA and a reasonable accommodation, means another vacant position. It's already open. You don't have to kick someone out of their job to accommodate an employee, and the employee has to be otherwise qualified. So this means you don't necessarily have to train another employee for another position that they are not otherwise qualified for. Now, if you would provide every employee who was hired for that position certain training, you need to provide training to the employee who's being transferred as part of an accommodation. But for instance, if the job required background in accounting, and you only hire people with background in accounting, you don't have to train someone accounting in order to transfer them to that position as part of a reasonable accommodation. In the cannabis setting, often this means moving an employee out of a production facility, and usually the two options are to a retail facility or to an office facility. And office facilities can be challenging for the reasons I just alluded to. Often employees don't have the training or experience required for a number of jobs in the office setting, but you at least need to look at that and look at the open positions. In the retail setting, that may be a possible accommodation, but again, you would want to continue that interactive process with the employee's healthcare provider, because depending on the severity of the allergy, obviously in the retail setting, there is still cannabis. And so although there would be less cannabis dust maybe than the production facility, there'll still be some cannabis. So depending on the severity, that might not address their limitations. Somebody asked a question about the difference between facilities that handle flower versus extracts, oils and other products extracted from cannabis. At least in this setting, I'll say it may make a difference because you may have a more severe allergic reaction to the flower and the manufacturing process involving the flower, grinding and so forth. You may have less cannabis in the air, cannabis dust in the air if you're just dealing with extracts, but you still could have an allergy. It's just going to depend on the individual, and that's why the interactive process with the healthcare provider is so important. I want to note that an employer is not required as part of a reasonable accommodation to create another position. And in fact, I would advise against doing that, because once you do that, there's sort of no going back. There's no, you've created the other position, so it's very difficult to make it temporary. You're also not required to grant the employee's preferred accommodation if another one is available. We've seen instances where an employee is offered to apply for one of the other open positions if they're otherwise qualified, and they don't want the other positions that are qualified. They want to work from home or have a special position created for them. Again, that's not required. If there is a reasonable accommodation available, you don't as an employer have to grant their preferred accommodation. And then I think the middle bullet there is key. An employer does not have to grant an open-ended leave of absence under the ADA. It's not considered a reasonable accommodation to grant an indefinite leave. Now, this is different from an employee or a medical provider being uncertain about the return date and being able to provide only an approximate return date. That may be, you may have enough information to assess whether you can, without an undue burden, leave the job open during that period. But if the medical provider or the employee can't say when or whether they'll ever be able to return to work, that's not a reasonable accommodation. And in that instance, if there's no other accommodations available, you may be looking at termination being the only option. And that's my final note here on the slide, is that these allergies can be very difficult or even impossible to accommodate. We've seen instances of employees, their allergies are so severe that they just can't be anywhere near cannabis, and there's no other positions open for which they're qualified. So I think it's important to know that going into this process, when you have an employee who comes to you with a need for an accommodation, is you have to know that may be where this is headed. And although that you can't shortcut the process, as Val said, you really need to go through the interactive process. It's part of your obligation under the ADA. What it means is you need to do so very carefully and deliberately, documenting every step, working hand in hand with your employment counsel, because it's very possible that if the employee is terminated, you will be in a litigation setting, having to defend your decision. Next slide, please. I'll just touch very briefly on this. The question sometimes comes up of whether or you're going to require a second medical opinion. And I have to say, in my entire career advising on disability accommodation issues, the only time I've ever insisted on a second medical opinion was in the cannabis setting. And as Julie has said, part of the problem you face in dealing with these issues is that medical providers, in general, people aren't educated about cannabis allergies, including medical providers. So they may have a patient and just be unaware that what could be going on is a cannabis allergy. So I've just put up here the EEOC's guidance on when you can require a second medical opinion. And basically it's if there is insufficient documentation from the medical provider. They're not providing information about the limitations. The provider doesn't appear to have the relevant expertise. So there's other factors that indicate the information is not credible. And you see this sometimes with doctors who really want to help the employee get back to work. And so they're just willing to say, they're fine, just give them a mask, or they're fine, no accommodations needed. But there's other indications that you have going on that's not the case. That may be an instance where after you've given the employee and their doctor an opportunity to correct, you require a second medical opinion, in which case you would want to require them to go to a medical provider who has cannabis allergy experience specifically. Next slide, please. Val, over to you.
Yes, thank you. So I just wanted to touch on this because a lot of people don't think about this, but if someone develops or aggravates an allergy, generally it's going to be covered under the relevant state's workers' comp statute. Not always, but most states do have provisions that would provide coverage. So if an employee could not work because of an allergy to cannabis, then they likely are going to qualify to receive indemnity and medical benefits under the relevant state statute, workers' comp statute. Also, if the company offers short or long-term disability benefits, an individual that couldn't work because of a cannabis allergy may be entitled to benefits under one of the short or long-term disability plan. However, I would note, generally, the short and long-term disability plans contain verbiage that if the condition is work-related, then the employee is not entitled to long or short-term disability benefits, or if they are, there's some type of offset. So in other words, an employee would not get to double dip. They would not be able to receive workers' comp, and well, if they would not be able to double dip without some type of offset. So I just wanted to make everyone aware of that. I think we have some hypotheticals next. Next slide. Next slide. Okay. So we have an employee working at a cultivation facility. She or he reports on and off asthma symptoms over the course of 6 months. She is permitted to use her inhaler at work as needed. The employee has a severe asthma attack at work one day, leaves her shift to go to urgent care. The next day, she wants to return to work. The employee provides a note from her medical provider, clearing her to return to work with no restrictions other than she has to have her inhaler close by. So in a situation like this, how many of you would let the employee return to work? Can we have a show of hands? Or I don't think anyone's responding. Well, in any event, in a case like this, if there is a medical note, I think you would have to allow the employee to return to work, but I would recommend that that the supervisor be notified and told to keep a close eye on this individual in case they had another severe reaction, at which point I would probably require that this employee or offer to the employee to see a specialist for her condition to determine if she could safely work. And of course, if she declined it, I might then demand that she see a specialist before returning to work. Because there have been situations that I know Julie's aware of where someone has a fatal attack and dies. So do you have anything to add to that, Julie or Aaron?
Just that, so I come in from the OSHA perspective, and so there's a couple of issues in this hypothetical that I would be concerned about. Number one is, you could face the possibility of a complaint. So let's say the person who sits next to this woman at work says, this company is not handling this appropriately. They're not understanding how serious they can be. They're letting her return to work, maybe without knowing what's going on behind the scenes. And they might call up OSHA and say, this company doesn't know what it's doing. These people are being exposed to hazards. This person could be very ill. And the next thing you know, you have OSHA showing up. So one of the things that you need to be aware of when you start having these issues is how to be prepared for an OSHA inspection and how to get ahead of that by being ready to know what to do when OSHA comes. That's sort of the enforcement activity perspective. My perspective is more public, whereas Aaron and Val tend to focus on this particular case. From my perspective, I would be concerned that the employer ought to be aware that this is a potential issue that's not being fully addressed, right? So we're not really sure that this medical provider is fully aware of the possibility that cannabis could be exacerbating an issue, right? So let's say this employee's had asthma for many years. The employer's like, oh, she's had asthma. It's just a flare up, run-of-the-mill thing, nothing to see here. And may not appreciate that asthma may get progressively worse as the person is exposed to cannabis over time, because cannabis can worsen certain symptoms. And so I would be concerned about whether or not the provider is understanding the context in which this woman is working.
Yeah, and then I just add one other thing related to that, Julie, and I think this hypothetical, which we've seen more than once, is highlights that it's really important to have your cannabis allergen program in place before you have this kind of an issue, because if you don't, it becomes much harder to take the steps Val was noting. It becomes much harder to say, look, we're going to require you to have another medical evaluation by someone with cannabis allergen experience. It just becomes harder to justify that this is a serious issue, that it's related to business necessity, because you haven't even put in a basic program in place. So yeah, I think it's really important to have that. And I think these examples walk the line of, at what point do you cross the line between, obviously we don't want to question their doctors or become doctors ourselves or employers. Is this just a one-off asthma attack? Or is this a situation where we potentially have a severe cannabis allergy? And I think it really walks the line of, when do you require that employee to go get the other medical evaluation?
I just thought of something else in this hypothetical, which has very few facts. The medical provider, to your point, may not even know what happened. She may have just said, hey, I need a release to return to work slip, and they may not be aware. So maybe what you need to do in a situation like this is, again, have her sign an authorization, send a note back to the doctor, basically laying out what happened and asking if she can safely work based on these facts. And maybe in that instance, her own medical provider would say, look, I don't think she's safe to work right now. We have to do X, Y, or Z testing to determine, right? So there are a number of ways you could approach this, but and I know Erin and I talked about this before. Generally, you can do a pre-employment post-offer physical examination to determine if an employee can perform the essential duties of a job for which you're hiring them. There are more restrictions on physical exams or testing of current employees. However, if you believe that the employee could be a danger to him or herself while employed by you, you can demand that they undergo another evaluation. And that's kind of this situation where you would be well within your rights if they had, let's say, an anaphylactic reaction to cannabis, to demand that they undergo testing before returning to work. Should we go to the next hypothetical? Next slide. Okay. An employee calls out sick for a week. She returns to work the following week and is required by the company's procedures for illnesses for more than 3 days. She presents a doctor's note clearing her to return to work. However, the employee says she believes she has a cannabis allergy that caused her illness and requests to transfer to a position outside the cultivation facility. So in this case, I guess the question is, would an employer be obligated to accommodate her request to be transferred? And I think in this situation, she's presented a note from a doctor that doesn't provide any restrictions or say that she needs to be in an environment where she's not exposed to cannabis. So I think the answer to this question is, you would not be required to grant her request for a transfer. But again, you may want to do a deeper dive or tell her you're going to need something from your physician indicating a reason why you need this transfer, and we'll go from there. Erin,
Yeah, I agree with that, Val. I think sometimes we see when employers roll out cannabis allergen awareness programs, employees can become hypersensitive to the concerns. And so you get requests where the otherwise objective facts indicate there's probably not a cannabis allergy going on here. But yeah, I think that the safest course would be to treat this just like you would treat any accommodation request that didn't seem to have an objective basis for it, and go back and say, okay, we will happy to discuss this with you, engage in the interactive process. You're going to need to provide some support from your medical provider that this, as to your limitations and why this accommodation would be necessary. Yeah, I think this is an easier case than the first hypothetical for sure.
Great.
From my perspective, the way this could be an issue where it comes to me is this person might be dissatisfied with how the company has handled it. So they call OSHA and they say OSHA is not handling a health and safety condition in the workplace appropriately. They could also say the company is retaliating against me for raising a health and safety concern. And now you have a whole nother set of problems on your hands, which is dealing with a retaliation complaint, which is complicated in dealing with OSHA. So just as a FYI, that something that starts out as an employment law issue could become an OSHA issue as it plays out.
And I would just add on these hypotheticals, a lot of times when you're in the cannabis industry, and I know that some folks here are not, the employee who's calling in sick or calling out sick might be a very low-level employee who's calling out to a slightly higher level employee. So this isn't making its way up to the executive office to deal with these issues. And so I know that my colleagues here have hit on the importance of training and proper supervision. These things kind of do start at your lowest level employees and making their way up, because the call is not coming to the C-suite to say, hey, there's an employee who's been sick for a week. And how this gets handled could be at a level where someone might not have the proper training to spot these issues.
That segues a bit into one of my comments about OSHA was, if you are the subject of an OSHA investigation, it's very important for the company to present the position that it cares very much about health and safety. And that message needs to come from the top. And this is a message that I'll give to anybody in any industry, to be prepared for an OSHA inspection, to be prepared for an incident, and to convey the message that you really care about doing things right.
Next slide. Next slide again. Thank you. So we mentioned at the beginning that the emphasis here today is on the occupational setting, not on the personal consumption, but the questions are going to arise from consumers. You know, I hear that employees are having cannabis allergens. How can I, as a consumer, ensure that I don't have one of these? These are big topics to discuss. These are topics that lead to product liability, recall, and other consumer safety issues. Just as a side note, we are seeing in California right now a lot of complaints being filed arising from recalls where products are being claimed to harm people. Again, this is the product liability space, not the occupational setting, but the two often kind of overlay on top of each other in the general public's mind, not in our minds, but in the general public's mind. So it's something to keep in your minds if you are talking to your employees about this, that this is not a consumer safety issue. This is not something that a customer needs to worry about right now, but there will be questions, and figuring out how to answer those will be important. Likewise, cannabis processing and cultivating facilities are not sealed off to the rest of the world. I can tell you from personal experience, I've walked through many of these, and vendors, customers, there's people in these facilities walking around, having tours, and there are potential exposures that exist in those contexts. So being sure not only from the employment perspective, how you're going to handle what's going on in your facility, but also as to who's coming in and what they might face upon entry. Next slide, please. Next slide, please. The three main things that we'd like you to walk away from this seminar with are, number one, that awareness is essential. OSHA has this, you knew or you should have known. They charge with knowledge of health risks presented by these cannabis allergens, even if your company only has limited awareness about this or doesn't have any education about this. Going back to my first entree into this, I didn't know about this, but when Julie started talking to me about it, she was showing me things from 2016, 2017 that clearly showed an awareness in the industry. So this more objective, knew or should have known, not the subjective, what you actually did know, is what's going to be the governing standard. Second, consider a spectrum of activities and prioritize the health and safety initiatives. There's many things you can do. We talked about a lot of them today. These could include an awareness program at a minimum so that folks know what we're talking about. Engineering controls that, again, can go from small adjustments to major facility overhauls, HAZCOM program changes, and medical screening and surveillance initiatives. Just being aware that these issues exist and that physicians might not know about allergy testing for this, but if your employees know to ask the physician, that can be an education point that helps the entire ecosystem. And third, the HR interactive process must be quote unquote textbook. Due to the nature of cannabis allergens and the limited accommodations that would be available to someone in this facility, again, you know, the person with peanut allergy working in a facility that processes peanuts, same context, that litigation is likely to happen and has been happening. So HR professionals should work closely with experienced employment counsel to mitigate risk. That's not just a plug for us, that is the truth. And next slide. Our next few slides, which you'll have, you're not, you know, needing to start like furiously writing this down or screenshotting, but we wanted to provide you some references that inform our materials today. So we'll just flip through the next few slides, but know that you have them and you can look at these materials as well. Next slide. Next slide. And our last slide is Q&A. We actually did make it here with 3 minutes to spare. I'm going to give our group here a big shout out for that. It usually doesn't happen. Do we have questions in the Q&A that we could turn to?
There is one that we haven't yet addressed, which is whether we recommend any particular steps employers should or can take in the initial application or hiring process. I think this is a really, really good question. And I think Val and I could probably talk about this for a long time. I mean, my first thought is there probably is a case to justify requiring employees who work in a cannabis production facility at the very least to undergo a medical evaluation to test for a cannabis allergy. I'm going to stop short of recommending that step though. I'm interested in Val's thought. I mean, one, I think it'd be quite expensive, and at least anecdotally, we're seeing cannabis allergies, although they're not uncommon, they're not prevalent. You're going to have a very small percentage of your workforce who's going to be impacted by these, certainly in any severe way. So I think you're maybe better dealing with that as in the ADA reasonable accommodation process, but I don't know, Val, if you see that differently.
Yeah, we did talk about that, and I know a client had talked to Julie and I about doing that, kind of more preventative or, again, it gets into the question, is the individual able to perform the essential job duties? So I think to your point, it could be quite expensive. I don't know if there's any inexpensive testing that could be part of a pre-employment physical that, I kind of like the idea because then you don't have to go through all the paces if they do develop some type of allergy, and you don't have to torture yourself trying to find an accommodation if there is any potential accommodation. But again, this is so new, there's not a lot of case law on it. I think you would be within your rights to ask because again, you could prove business necessity, right? That they're going to be exposed to a lot of cannabis, and if they have some type of allergy to it, it could be dangerous to them. So I think you could justify it. I think it's probably more of a cost benefit analysis though.
I would make the point that it's not going to solve your problem because some people will develop cannabis allergies over time. So just because somebody comes out clear in the initial process doesn't mean you might not have a problem 3 weeks, 3 months, 3 years from now. So don't rely on that. My other comment about the initial application hiring process is that from my perspective, from an OSHA perspective, there needs to be an education and training component right away, which is not the stage you're talking about, just pre-hiring, but it's really promptly after hiring, because people should be aware from day one of the possibility of developing these allergies if they don't already have them.
Yeah, I'm with you, Julie. I think it should just start to work into the initial orientation, at least at a cannabis production facility. Anecdotally, as Julie said, these can develop later. Anecdotally, that's what we're seeing, that it's not employees in their first week of work or even their second week of work it gets progressively worse over time to where 6 months in, all of a sudden they're just having a whole host of issues that they didn't have before. And so the awareness helps that when it does arise. Yeah, and so I tend to think that's your best bet. Do the training up front and deal with the accommodation process. Anecdotally, I'm not seeing these so much in outside of the production setting in retail facilities, or to the question that someone asked earlier about a facility that doesn't handle flour but is just handling extracts. Definitely possible, but I haven't seen at least the severe allergy issues come up in those settings.
We are at time, and I want, on behalf of my co-panelists here, to thank you again for participating in today's CLE webinar. In about 30 days, you will receive an email with a link to your CLE certificate if you were looking for CLE. Your webinar login details will be used to process these certificates, so no additional steps are required by you. As a final reminder, the code word requirement was only for those seeking credit in Kansas, New York, New Jersey, or Pennsylvania. If you have any further questions, need further assistance, please don't hesitate to reach out. If we didn't get to your question, we will look over these after our presentation here and reach out to you. And thank you very much for joining us today. We hope that this was beneficial.